Hi, folks. I'm going to call to order the meeting of the Sentencing Guidelines Commission. It is May 2nd, or May 9th, 2024, and I will ask Director Wrights to read the roll.
Roll call. Vice Chair Larkin.
Present.
Larkin present. Commissioner Crutchfield.
Here.
Crutchfield present. Fraze.
Here.
Fraze present. Knutson.
Here.
Knutson present. Ladd.
Present.
Ladd present. Middlebrook.
Present.
Middlebrook present. Moore.
Present.
Moore present. Morath.
Present.
Morath present. Morin.
Present.
Morin present. Mueller.
Present.
Mueller present. Reeves. Madam Chair, Commissioner Reeves is present. She must have just stepped out of the room.
Okay.
So I don't know if you want to mark her as present.
We'll just keep going and we'll mark her in when she comes back in the room.
Okay, Commissioner Saxena,
Present.
present. Chair Mitchell,
Present.
Chair Mitchell present. Roll call. Commissioner Reeves.
Present.
Reeves present. Madam Chair, there are 13 members present, no members absent.
All right, and with that, we have a quorum. The first item on our agenda is approval of the draft meeting agenda. I would entertain a motion to approve the agenda.
So moved.
Commissioner Knudsen makes that motion. Do we have a second?
Second.
Second by Commissioner Larkin. Any discussion on the agenda? Seeing none, we'll go ahead and vote on that.
To the Knutson motion to approve the meeting agenda. Larkin.
Yes.
Larkin, yes. Crutchfield.
Yes.
Crutchfield, yes. Fraze.
Yes.
Fraze, yes. Knutson.
Yes.
Knutson, yes. Ladd.
Yes.
Ladd, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Morath.
Yes.
Morath, yes. Morin.
Yes.
Yes. Mueller.
Yes.
Mueller, yes. Reeves.
Yes.
Reeves, yes. Saxena.
Yes.
Saxena, yes. Mitchell.
Yes.
Mitchell, yes. Madam Chair, there are 13 members, 13 votes in favor, no votes opposed.
Great. With that, the motion is approved unanimously. Next item on the agenda is, I was expecting the meeting minutes. Can we do that first?
Sure.
Let's, even though I just asked you to approve the agenda, I want to take something out of order. Let's just do the approval of the meeting minutes and get all the technical stuff out of the way. So you all should have received the minutes from April 11th, last week. I would entertain a motion to approve the minutes from April 11th, 2024.
So moved.
Commissioner Reeves makes that motion. Do we have a second?
Second.
Second by Commissioner Larkin. Any discussion on the minutes, on the motion? Seeing none, go ahead.
To the Reeves motion to approve the April 11th, 2024 draft meeting minutes. Larkin.
Yes.
Larkin, yes. Crutchfield.
Yes.
Crutchfield, yes. Fraze.
Yes.
Fraze, yes. Knutson.
Yes.
Knutson, yes. Ladd.
Yes.
Ladd, yes. Middlebrook.
Yes.
Yes. Moore.
Yes.
Morath.
Yes.
Morath, yes. Morin.
Yes.
Yes. Mueller.
Yes.
Mueller, yes. Reeves.
Yes.
Reeves, yes. Saxena.
Yes.
Saxena, yes. Mitchell.
Yes.
Mitchell, yes. Madam Chair, there are 13 votes in favor, no votes opposed.
With that, the motion is approved unanimously. All right, I have the sad duty to announce that Commissioner Morath will be leaving us. This will be her last commission meeting. Am I correct on that? Right, this will be her last commission meeting. And I think Commissioner Larkin brought some treats to recognize your service here today. And I would like to also just say a couple of things. Commissioner Morath was appointed by Governor Walz in November of 2021. She represents the victim constituency on our commission and has done a really fantastic job of bringing forth the viewpoints and perspectives of people who have been victims of felony crimes. I've found your contributions to the commission to be really, really, I'm searching for the right, I'm not thinking of the right word, but really compelling is the word I'm trying to search for. I really appreciate how you have brought us not only perspectives of people who have been victims of crimes, but also research on that very topic too, so that we get a really balanced view of how we should be thinking about these issues from the perspective of victims as we consider the various topics that we've considered during your time here. Some of those things have included an examination of sex trafficking. That was fun. And you were also here for an examination of criminal history score. And you helped us to launch the Sentencing Guidelines Comprehensive Review. I really appreciate the service that you've given to us during that time. And we would like to recognize you with a certificate, so you'll have to come up here. Thank you so much. Thank you. I just you can put in it later. Perfect. Thank you. Appreciate it so much. You want to say anything, please feel free.
Good speech is my favorite.
Yep.
No,
Yes.
feel very fortunate to have been able to have served alongside all of you these past few years. The breadth of experience and wisdom represented on the commission is just truly incredible, and I feel like it's been very incredible for me every month to come in and just be able to be a sponge. Really kind of bittersweet. I'm gonna miss these stimulating conversations we have here, the work that gets done, and I think having this opportunity is going to set me up for success in this exciting new venture I'm going to embark on. So thank you all.
My screen decided to go to sleep while we were talking.
It's the MAD update.
Gotcha. Yeah, so item number 5, we're going to continue with that comprehensive review, and we have some folks here from MAD to give us an update on the public engagement piece of that. So Charlie, Salu, and Shamsa, I'll give it over to you.
Thanks, Madam Chair. So yeah, we're glad to be back with you all today. I'll share my screen in the meeting. So one moment. So yeah, my name is Charlie Selu, and I'm back with my colleague Shamsa to talk about the public engagement process that we're working on together as part of the review. So I'll start just with a regrounding in our timeline and where we are. So it's probably really small if you're in the room here, but so we're in the engagement activity kind of window through the end of June, where we're hosting up to 30 engagement sessions across the state. And so we've been actively scheduling these, kind of still in the early middle part of hosting them. And we've been trying to join existing events where possible. A lot of the times we're creating new events with partner organizations. And then we're also creating a survey for people who aren't able or prefer not to participate in a online or in-person setting, but prefer to provide written feedback. Just a reminder of where we're going. So over the summer, we'll summarize high-level findings from this initial wave, and in September, bring back to you all the findings and get your input on what's still missing. So there's another window we have in the fall to do additional engagement. That could be other sessions, it could be other surveys or other methods, depending on what the gaps are. So we'll bring an initial set of findings to you in September, do more follow-up engagement in the fall, and then have a final report early next year. But I'll hand it over to Shamsa to talk about the session so far.
So as you all know, we are planning to have up to 30 sessions in our first wave of engagement. So far, we have 7. We'll be hosting 7 sessions by the end of next week. Those include folks from the DOC group. We had 3 DOC groups, so we've conducted already 2 groups for the DOC. Probation officers. We've also had a session with the legal service providers, specifically with working with indigenous communities. So that session included the Regional Native Public Defense Corporation, as well as the Anishinaabe Legal Services and Indian Legal Assistance. We have a session coming up with the public defenders, the third DOC group, and then as well as the CCA officers and the CPO officers, and also one session coming up with the Minnesota Freedom Fund organization, which will include those with lived experiences as well as their support staff. As you can see on the slide, the middle section and the right section. In the middle section, we have audiences which we need more outreach and scheduling. So that includes the judges, the prosecutors, law enforcement, and general public. And then the column on the right, which includes the audience which we need to have more conversation about how we will approach them. This will be the tribal nations as well as the currently incarcerated individuals. In regards to the middle section, we are planning on sending out our written survey format to the judges. The prosecutors, we actually have a session set up with them, but within that session, we've realized that the participants in that section does not include prosecutors from the Twin Cities area, which is Hennepin County and it's Ramsey County. So we will need more efforts in trying to conduct more sessions with those folks. For law enforcement, we have one organization that reached back out to us. So we'll need assistance with also getting more participants with them, and then the general public as well.
And then on that last column, as Shamsa was mentioning, if we do want to do work with tribal nations, I think we had mentioned before, we don't see ourselves at MAD as the right partner on our own to do that work because we're your consultants and advisors, and we think that would be more of a kind of consultation process that would be a little bit more formal. And then similarly, but different, of course, if there's a desire to hear from currently incarcerated people, that would be a process we need to plan and be very intentional about. We do have, as we mentioned, plans to reach recently or formerly incarcerated people, but that's a different kind of category. So maybe we'll just pause and see what questions or comments the commissioners have for us.
Commissioner Larkin.
As to the judges, Jeff Shorba had indicated he was willing to send the survey to all of the judges across the state. Is that what we're still going to do?
Yes.
Okay.
Well, we need help with disseminating and making sure that we get enough judges to respond to those written survey formats.
So it's really just in the middle there because we're not, until we send it out and we know we have responses, we're not confident that we're going to get as much as we want. And so it's just kind of on our radar still as something we'll need to monitor.
Understood. I just want to make sure it is going to be sent out to everyone.
Yep.
Commissioner Fraze.
Madam Chair, just piggybacking on the Commissioner Larkin's question, is there a way, or is there already in process a way to get leaders of the bench, the Chief Justice, other respected leaders to encourage the judges to return the questionnaires? Because I think that the judges are the people who probably know the guidelines best, for better or worse. And so I just think it's critical to get a good response from them.
No, one second. I'm going to let one of the judges respond to that. Commissioner Knudsen.
Absolutely. And I can certainly help reach out and make sure that happens. Talk to the Chief Justice and Jeff Shorter and work with them. See him next week. So I 100% agree. So there's a number of things we should think about. Reminders and maybe a letter from Shorba, or even better from the Chief Justice.
Commissioner Larkin.
Maybe between the two of us, we could each commit to calling one of the chief judges personally to encourage them at a bench meeting.
That's a good idea, too.
If you want to split the districts with me.
Sure. Yeah.
Okay, and then is that good on the judge front? Because then I think Commissioner Mueller wanted to talk about law enforcement, and then Commissioner Lively wanted to talk about prosecutors. Go ahead.
I just want to touch base and see, I know, made some email connections with the executive directors of the chiefs and the sheriffs, and PPOA as well. Is there anything else that I can do I know you're talking with Executive Director Potts, Chief, and Stewart with the sheriffs. Just is there anything else that I can do to help with those connections?
Yeah, so the Minnesota Sheriff's Association, we've gotten a response from them, and they're ready to, once the survey is ready, and Charlie will go over the survey with you all today, but once the survey is ready, they are willing to disseminate it through their newsletter. But I have not heard back from the Minnesota Chiefs of Police Association as well as the Minnesota Police and Peace Officers Association. So probably giving them a nudge will be helpful.
Okay.
Yeah.
We have, there's a Chiefs board meeting that we have next Thursday. So a nudge prior to that, and then I can bring that up. And I have no doubt that at least with the Chiefs, that'll be no problem getting that information out. And I can touch base with Brian Peters, the executive director with MPPOA as well.
Thank you.
Thanks. Thank you. And then Commissioner Lett.
Thank you. Just so I understand what the issue is with the prosecutors, it is that you do have representation from counties, but you just don't have Ramsey and Hennepin engaged. And the reason I ask is because next week we have our board of directors meeting along with our executive committee meeting next week, and so I can lean into some of those issues and kind of go there. But I want to make sure I understand exactly what the issues are.
Yeah. No, I'm actually in contact with the director. He personally picked out participants for that session, but when I looked at the information, I realized that there wasn't any participants within the Twin Cities area, and that would include the Hennepin and the Ramsey folks. So getting some more participants within that area would be helpful.
I think what Judge Small did as our executive director, he actually put out a request for volunteers, and so he might afford those names to you, but there were people that actually were volunteering. We actually asked for not only county attorneys, but assistant county attorneys, folks who are really kind of in the trenches, because some county attorneys are not working at county attorneys. That's not me, by the way. I mean, some county attorneys don't carry caseloads, so they don't have the same lived experience that some of these things that maybe will be flushed out. But I'll be happy to bring that up next week with at the board of directors. And I know that John Choi and somebody, either Mary Moriarty or somebody from her office, typically attends those meetings, so we can encourage some representation from them to get that going.
Yeah, I'm actually, so I've worked at the PD's office, so I actually reached out to some folks at the PD's office who work in the felony department. So the Hennepin County, but the Ramsey County right now is particularly the one that I don't have any contact there. So I'm getting some folks from the Ramsey County would be really helpful.
All right. Any other questions or input on the connections side of things? Did you have some? You have more, I think,
Yeah.
right? Go for it.
Yeah, so feel free to keep chiming in on that, but wanted to, as you mentioned, kind of preview what we're doing with this survey. So our primary form of engagement in this wave is the sessions that we're doing both virtually and in person. To supplement that in this wave, we've developed two surveys. So one is a post-session survey for people who are participating in these online and in-person engagement sessions, because we know for some people, it's a really active conversation and it's hard to get everything you wanted to say. You haven't thought of everything right away. So we're sending people a survey after we wrap up the session to provide additional input and ask some additional reflection questions. And then in addition, we have an open engagement survey that's designed to mirror the questions that we ask in the in-person and online session. So it's still very open-ended. It's designed primarily originally for groups like judges, where we know there's a preference to provide written input. But we designed it in what we're thinking of as a no wrong door approach, in that it doesn't assume that you're a judge or assume you have any particular role when you're answering it. It kind of asks you some preliminary questions that guides what it asks. So it could be anyone could take it, I guess is what I mean to say there. And while we're planning more public engagement and input in the fall, we didn't want to close off participation if people got this survey. So again, it's audiences that preferred written communication, or when we're doing the scheduling outreach, if there's individuals who can't make a session last minute or who aren't able to attend one that we've scheduled, we're also going to be sharing the survey with them so that they have a means to weigh in the process. So I'll go ahead in a second here and share the survey. We haven't launched it yet, but we'll launch it after today's meeting, assuming there's no major questions or concerns from.
Looks like we have a question from Commissioner Moran.
Oh yeah, go ahead.
Yeah, I just had a quick question on that slide, the prior slide. Sorry, it just came to me. One of the things you said is people that need engagement. You were talking about the people that were currently incarcerated. Would a good avenue be through the Department of Corrections? I have some context there.
Yeah, absolutely. So I think the question is, yeah, just thanks for bringing us back to that right part of the slide. So it's a question of, how would we do that and what would be the right path? And welcome ideas from you, from Chair Mitchell, what's the appropriate way to plan that if that's kind of the path we want to go down.
Okay.
We imagine that would occur in the fall, just because it would involve, we imagine would be a decent amount of planning there.
Okay. Would it be beneficial to get in touch with some contacts to, I can ask them what they think would be the best option to give some input?
So Commissioner Moran, since I work at the Department of Corrections, I can answer this one, but it's challenging because it's really like research. And so these types of things definitely usually have to go through our research proposal process. And it's a matter of timing, right? Like,
okay.
I don't know if there's enough time to get through that process in order to get meaningful information. So we can sort of figure out what that process might look like if the commission is interested in that. But I do know that you are also talking to formerly incarcerated individuals as well. So it's not like we're not talking to that group at all.
Correct. And so I think it's just a question of what is the desired approach, right? Like we could, one option is if we know it will take a really long time to get approval, we could start down that path and then know that you may be in a different place in your review journey, so to speak, when we're ready. But it may actually be a better place, honestly, if you can share a little bit where you're headed directionally. We also could focus principally on the formerly incarcerated people, because it's obviously easier to reach population from a process standpoint. But yeah, curious the commission's thoughts.
Okay.
Go ahead, Commissioner Moran.
Well, I'm satisfied with that. I didn't mean to step on your toes, Chair. I just thought I had some contacts and thought I could try to help in this manner, and just trying to provide any input where I can. So.
Yeah, no offense taken in any way. I think that's actually a great idea, Charlie. If we get it kicked off, then we might be at a different spot by the time you're able to go in, but then we would have that opportunity. So I love that you're thinking, because maybe we'll even be a little further down the road with some ideas we could get feedback on too. So that I would support that.
Yes, we can follow up with you and with staff on how to get that kicked off. And then on the tribal nations front, I think we talked about this in pieces too of, we just don't think we're the right partner, as we've said, in terms of we would want that to be probably the chair or members of the commission doing that work. Rather than, we could support it and help structure it, but we don't want to be the face of the commission when it comes to the government-to-government interactions. Any other thoughts on this slide?
Nope. I'm good. Thank you.
All right, well, I will jump quickly to the survey. So this, when it shows up here, so this is showing you what it looks like on a computer on the left and then on a phone on the right. I know it's kind of small in both for those of you in the room, but if you're online, you can see it a little bit better, hopefully. So as I mentioned, we have two different versions of the survey. This one is for that more open link. And so it asks you an initial question of your level of familiarity with the guidelines, because we know that for some people, for example, law enforcement, even though they are in the system in some ways, individuals' exposure to the current guidelines may vary. And so we kind of offer people two options. They can ask to be have specific questions about the current guidelines, or just general questions about criminal sentencing. If they do say that they want specific questions about the existing guidelines, they're given the questions that we ask in the in-person and online sessions for practitioners that we're hosting right now around what's working well, what provisions are confusing or challenges exist and what changes people would recommend. And then everyone gets these more broad questions about what would make criminal sentencing more fair and just, clear and understandable. And the question that this group gave us, which we really like, about when is prison an appropriate punishment. And then they also have an opportunity, if they want, to share a more specific personal experience, because we know some people come to us with a very personal story that they want to share, and so there's an opt-in to share that. Then we ask demographics. So I would love the group's eyes on this quickly of for the roles of whether these roles are named correctly and resonate with each of you. So we have prosecutor, defense attorney, legal aid provider, judge, law enforcement, probation, PSI investigator, supervised release officer, or community supervision officer, and then service provider. People could also select other, none, or prefer not to answer. As the group looks at this now, any feedback on anything so far, but in particular this role question?
Thank you.
Commissioner Knudsen.
How about elected government official other than judge? So we're looking at county commissioners, city council members, legislators particularly.
Yeah.
So we, if we're going to solicit opinions from any of those folks, which many of them will probably have opinions, it might be helpful.
That's a great point, because we don't have a current plan to reach out to those audiences, but we absolutely could, as part of this, reach out to local government officials or others that you think would have perspectives that would weigh in here.
Well, I really encourage us to do that. When we're looking at, just broadly on these sets of guidelines, we want to change this, we want to do this, we get this suggestion, that suggestion. So much of this is mandated by the statutes, by the legislatures. The legislature, creation of the sentences and that kind of thing. So I think it'd be really helpful to solicit their input on the guidelines.
I think that's helpful. And then we also ask about personal roles, knowing that people can obviously have both at the same time. You could have a professional role and a personal role, or both. So I'll show that list here as well. And then we ask about race, ethnicity, and where people live. If people, hopefully most people live in Minnesota who get this, but we do want to ask in case it gets more widely distributed than we intend. Then there's this map where people select where they live, and on the back end we group it into the kind of 5 regions that we're using for our engagement planning, and then they can submit the survey. Yeah, that's all we have. Any additional feedback or?
Commissioner Mueller.
I just want to, I think it's a good time just to say thank you to both you, Charlie and Samsha. When we first sent out the engagement to our stakeholders, it was literally just right around the time of the tragedy in Burnsville, and I just asked for a little bit of grace. Didn't seem like the appropriate time to engage law enforcement leaders on this issue, and they provided grace and gave us a little bit of time, and then gave me the nudge when it was appropriate, like, hey, we need to move forward on this. So I want to say thank you for that.
Any other comments or questions? Well, thank you. I am so excited to see this moving forward. I can't wait to hear what you guys learn. The survey looks pretty slick. So I think that between all of the different efforts that you guys are engaging in, we're gonna get some really interesting stuff. Thank you.
One point of privilege to say too, if we don't share themes really yet because we're just way too early, but I do just want to call out that a couple of different sessions. Really appreciated MSGC staff and Linda in particular for all of the work that the staff does in interacting with them. And so I just wanted to mention that right away.
That's awesome. Thank you so much.
All right, thank you.
Let me see, what are we up to? All right, so continuing with comprehensive review, we asked Professor Wright to join us to talk about the purposes and principles based on his research and experience. So I'm going to hand it over to Professor Wright.
Thank you, Chair Mitchell. Let's see if I can share my screen.
I probably need to do something here.
I think this will work, but let's see. Okay, hopefully this will show you the title. Okay, I think we're in business. Well, I was asked a couple meetings ago, I think, by Chair Mitchell and Director Wrights to prepare some comments on what state systems around the country, especially state guideline systems, have been doing in the realm of the purposes of sentencing guidelines, the purposes that we're trying to advance when we sentence people in our various states. Now, this is an area of research that I've been involved with before. Over and over again, we did this kind of research for the Model Penal Code. It was finalized in 2017, so this was really a chance to get immersed in the more current set of circumstances. And I just want to note that I had a lot of help from a law student research assistant, Amy Cohen, who's here today. We never would have gotten through all 50 states in an intelligible way without her help. And she's just been an extraordinary legal research assistant for me for a few years now. And unfortunately, she's graduating day after tomorrow. But she will be clerking with the Minnesota Supreme Court, so she's not lost to public service. But just wanted to recognize Amy. So this is all research that's current as of this week or the last couple weeks. And what I thought the relevant subjects should be came from a sense of what this commission has been talking about in the comprehensive review, and also came from a sense of what this commission for a long time has been doing well. In many ways, the Minnesota sentencing system is far ahead of other states, and not just in articulating the purposes of its actions, but in getting them to apply in a way that makes a difference. So this state has been a leader in that, and even on the world stage gets notice for being advanced in many areas. So in my slides, I'm not planning to rehearse things that Minnesota's already doing, that I might do if I were giving a presentation in another state. The subject matter, I think, includes what states say about the purposes judges should be thinking about at individual sentencing proceedings, the purposes that sentencing guidelines should build in to help with that process, and also purposes that have to do with the sentencing system as a whole, as opposed to any one case at a time. And in our research, the research that Amy and I did, we looked at statutory sources, sentencing guidelines in every state that had sentencing guidelines, including the commentary, maybe policy statements of the commission, and in some states, appellate case law. Okay, we didn't get to the bottom of all of that, but we did a pretty thorough scan across the whole country. And the one footnote I would drop about those sources is we didn't keep precise counts of what we were seeing, but there are about a dozen states, I would say, that just have no really coherent statement of what the purposes of sentencing are or how they should be applied. So we're talking about the remaining 38 or 40 jurisdictions. And the other caveat I would give is from Yogi Berra, who said famously that in theory, there's no difference between theory and practice. But in practice, there is a difference. So primarily what we're looking at here are sources that declare what the state wants to declare it's doing, but how successfully things are actually being implemented is, a different and a harder question. So it's always seemed to me, and it certainly informed my work as model penal code sentencing reporter, that it's not enough to just think about what the purposes of your system should be. The additional question is, how are they going to be implemented? Because otherwise they tend to be window dressing more than actual pillars of the system. Now, in conversations in this room and in the text of Minnesota sentencing guidelines, we've been focused on dimensions of public safety and proportionality. So I plan to talk a bit about each one of those things. Whoops. Hold on a second. Oh, I'm sorry. I'm pushing the wrong button. No wonder I'm getting myself confused. Okay. And like Minnesota, most of the states that have expressions of how the purposes of sentencing or sentencing guidelines are viewed, most of the states have some version of public safety or proportionality as primary leading goals of the system as a whole. Now, in addition to these, you might call these substantive purposes, what we want sentences to do, the shape we want sentences to take. There are cross-cutting systemic purposes that apply no matter whether you're worried about proportionality or a particular utilitarian project. You're always going to be worried about the systemic goals of things like rationality, neutrality with respect to demographic and personal factors, and the idea of resource constraints. Minnesota is absolutely a leader here, and the idea that correctional resources are finite and need to be managed. We need to set priorities. Now, the systemic goals that I just had on the slide tend to be much more common in sentencing guidelines jurisdictions than in other states. And again, is an area where Minnesota is a leader. But with that, very sort of general introduction, there are a couple critical issues that I'll be talking about throughout the talk. One is a lot of these words like proportionality or neutrality or whatever they may be tend to be kind of broad and abstract. People might have very different definitions in their own head of what that means to them. So the definition of these terms makes a difference from state to state. And also, as I said earlier, apart from definitional questions, what's being done in a given system to actually effectuate the application of policy in practice. Okay. Now, the outline of the presentation, the rest of the presentation basically has three parts. One looks at what different states say about public safety and what perhaps we don't have in Minnesota that some other states do, or that the model penal code suggests that could be considered. Same thing for proportionality. And then finally, a question that you all have focused on in this room much more than once in the last several meetings is what should the thought process or the reasoning process be when selecting one form of sentence versus another, prison versus probation versus some other. And so I've tried to pull some materials from different states that address that question in ways that might be useful to you, to Minnesota decision makers. Okay, well, to start with public safety, there's near yet unanimity across states that any definition of public safety should include the full complement of utilitarian mechanisms that are aimed at reducing future criminal behavior. Okay, and by that, using the model penal code language, it's common to see states refer to public safety under multiple subheadings: offender rehabilitation, deterrence, incapacitation or confinement of dangerous offenders, and reintegration of people back into the community. So just to give you some examples of state statutes, I won't read each one out in full, but anyone who looks at the slides can go back. This kind of multi sort of sub-purpose definition of public safety is found in lots and lots of states. Some examples here from Alabama, California, Massachusetts, that all use words like public safety or public protection and then say what they mean by that. And they include things like rehabilitation, sometimes even restoration, deterrence, all the different ways that a sentence could, hopefully in the future, influence crime rates. Texas is similar in giving the sort of sub-purposes. So that's something that the commission can think about. Interestingly enough, I found only one state that defined public protection solely in terms of incarceration, imprisonment, and the state that does that will surprise you. It's Oklahoma, and where public protection is defined solely in terms of incarceration. And further, in Oklahoma, the statute says that all of the other purposes of sentencing don't even come into operation until the interests of public protection have been addressed. So that's not necessarily one I would recommend, but it does go to show you that the states are very different in how they articulate these things. Now, one dimension of public safety that I would sort of raise in the conversation for the commission is sort of the other side of crime reduction, which is that criminal sentences should not actually be harmful in terms of creating more crime than they're preventing. And in my years with the model penal code, this was, I don't know, the insight that hit me most often, that in so many domains of corrections, we do things where you can raise the question, is this making matters worse as opposed to better? And is it worthwhile to just come out and say in the text of the statute or in guidelines that one of the leading purposes of sentencing or sentencing decisions or sentencing guidelines is to avoid imposing sanctions that increase the likelihood someone will engage in future criminal behavior? So in the model penal code, this is now one of the top 4 leading purposes, right, along with proportionality and public safety, as we've talked about. Is it instructive? Is it useful to remind people in the system, whatever you're doing, avoid making more criminal behavior in the community? And there are some states that have language to this effect, either broadly or in particular contexts. In Maine, in statute, one of the chief purposes of sentencing in that state is to minimize correctional experiences that serve to promote further criminality. So this is very close to my heart as model penal code drafter. Other states like Colorado focus actors in the sentencing system on reducing the potential that someone will engage in criminal conduct in the future. To me, that's a similar sentiment. Massachusetts has some very interesting things in its sentencing guidelines, where with respect to sanctions like probation or economic penalties, the guidelines alert judges or admonish judges to think about the ease with which some of these sentences can make things harder on people who are trying to reintegrate or reestablish a normal life. And this is Massachusetts, not Minnesota, but in Massachusetts, the sentencing guidelines say that probation term should ordinarily be no longer than 3 years. Okay, that's the number they picked, but at the bottom of the slide, their reasoning was that a longer period of supervision could actually make it more difficult for the probationer to make the transition and become a functioning member of society. And the guidelines say something similar about the intensity of conditions or special conditions that are placed into probation sentences. An excessive number of special conditions may increase rather than decrease the likelihood of recidivism. So it may be a matter of semantics, but it's always struck me as useful to sort of look at both sides of the coin in terms of what we're trying to do. Part of what we're trying to do in criminal sentencing includes what we absolutely do not want to try to do or want to try to avoid. Maryland has a statement, similar effect about the use of incarceration, which it can increase the chances that especially low-risk offenders might recidivate in the future. Okay, so those are the main points that I wanted to make about public safety, just having to do with definitions and the way we turn the idea around in our mind and look at it from different angles. If there are questions on that, I could take them or just keep moving forward.
Any questions from the commission members?
Okay, well, I'll move on to proportionality. This is more of a potentially amorphous concept, and some people think it's so amorphous that it's just very hard to implement or make it work in any meaningful way in a sentencing system. I don't agree with that. The Model Penal Code defines proportionality, and this is something that is useful to do as the effort to render sentences in all cases within a range of severity that's proportionate to the gravity of the crimes, the harms done to crime victims, the blameworthiness of offenders. So there's a definition that includes what I call reference points. Proportionality is understood in relation to certain reference points. Now, when deciding what to do with proportionality in a system, many of us in the academic world who think a lot about this issue have tended to accept that the very idea of proportionality is a limitation, that no one can be in favor of disproportionate punishment, right? Even if we think it's achieving something like rehabilitating the offender or preventing crime in other ways, the punishment we impose on this particular person should not be disproportionate to their guilt and their responsibility. Okay. Now, it's surprisingly hard to find this idea of proportionality as a limit actually expressed in statutory or guidelines language. What I see in most of the other states, if not virtually all the other states that mention proportionality, is that it is listed among the leading purposes of sentencing, but it's not quite articulated that at the end of the day, no one's in favor of a disproportionate sentence. It should be seen as a limit, even if we think that there are crime preventive objectives that we have in mind. You wouldn't want to deter someone from speeding with a life sentence in prison. There'd just be a total mismatch between the effect of deterring speeding that you probably could get with that and the proportionality. Now, another dimension of proportionality that I think is generally accepted, but to me, again, can be expressed, is the proportionality is not just a limit, it's a requirement of a just sentence. Okay, and that does not mean that the severity of a sentence cannot exceed the boundary of proportionality. There are some crimes that demand a punishment, even if we don't think that we can achieve anything like rehabilitating that person. And so, at least I believe this strongly, that in very serious questions, just the gravity of the crime, the culpability of the offender requires a punishment of some severity, even if we don't think that person will be reformed or anyone else will be deterred. So those to me are kind of fundamental aspects of the definition of proportionality, although it still gets very complicated when we try to identify what the reference points should be for proportionality, either as a limit or as a driver of what a sentence has to be. Now, this probably the most cited reference points to proportion are similar to what's in the model penal code. Sentence should have this relationship to the harm that was done by the offender. I think it should include the harm that was done or the harm that was risked to some extent, and also blameworthiness or culpability of the offense. So those are two of the standard reference points that people talk about most often. But just to highlight a question that I think the commission will really grapple with later in the process of the comprehensive review, there's a lot to think about in asking whether proportionality in punishment in a particular case should depend on the current crime or the current offenses of conviction, or whether proportionality should also stretch out to include past convictions as well as the current offense. And I think that the commission will talk about this quite a bit in the coming months. But just to give you a survey of what other states say about this, the other states with sentencing guidelines, I think most of them, certainly many of the states without sentencing guidelines, take the position that proportionality as a primary purpose should make reference to the past criminal conduct of the defendant as well as the current offense. Okay, I have reservations about that, but the fact is, if you look around, the Minnesota guidelines say this: the severity of the sanction should increase in direct proportion to an increase in offense severity or criminal history. Okay, so the current guidelines statement includes both of those things in the idea of proportionality as a limit or possibly as a driver of severity. And if you go across states with guidelines, Arkansas, Massachusetts, Michigan, Oregon, Washington, there's just as many more that I didn't include in the slides because it gets ridiculous. But the majority view is that proportionality includes this. So I think it's worth asking the question whether this is the correct judgment and definition, but that's what other states say.
Professor?
Yes.
Isn't that where risk creeps in? Because we talk about proportionality based on crime, but when we talk about their criminal history, isn't that where risk to reoffend comes in, or is?
I think it does for a lot of people, yes, I agree with that. But there was a study that a professor at the University of Virginia did back in, I think it was the 90s, where he's a psychologist, and he had a lot of people who participated in the experiment to give their views on what proportionality meant. And one of the very clear findings that he got from the subjects of his study was that people thought that the propensity to commit crimes in the future, if they believed that made people more blameworthy, kind of in advance, their current condition of presenting that danger for them rolled into blameworthiness. So I think that's right. I tend to separate the two as utilitarian versus, the issue of risk as a sentencing factor is a utilitarian crime preventive idea when we're talking about things like what's justice, right? So to me, it seems more useful to try to separate them, even though in a lot of people's minds, that separation isn't there.
Thank you.
Yeah. Okay, well, as I say, the model penal code is skeptical of the approach of, in any powerful way, rolling criminal history into proportionality. And one of the main reasons for that is that when we include a criminal history as especially if it's a powerful part of the recommended or presumptive sentence in guidelines, I'm not sure that we're thinking about the fact that, well, whatever those past offenses were, they were met with the punishment at the time, if we're talking about past convictions. So there's been the prior punishment for those offenses, and should we think about that when counting criminal history in a newer case? What the model penal code says about that is here, if criminal history is used for purposes of assessing offender blameworthiness for their current offenses, the commission, that's the sentencing commission, shall consider that offenders have already been punished for those prior convictions. Okay, so it's an attitude, but an attitude that could make a difference in how one just ranks the force with which a sentence should get more and more severe as criminal history accumulates. Now, in some states, and I don't know how strong a claim to make here, but some states seem, in the language that they use, to limit proportionality more directly to whatever the current crime is. And that's what we're sentencing today. So again, this is just a sampling, but in California and Delaware, New Hampshire, it probably most efficiently just says all penalties should be proportioned to the nature of the offense, this offense. Okay. This may be an area where sentencing judges, do things differently. Right? We don't know for sure, but these are the statements of aspiration that we see in guidelines and statutes. Now, one of the really tough problems, I think, about a system that rests heavily on proportionality is, well, how do you actually implement it? How do you make it happen? In a lot of states, and we studied this carefully for the model penal code, proportionality may be stated as an important principle, but there's not necessarily any mechanism to sort of ensure that it plays through the criminal sentencing system. And just one basic data point from that is that every state has constitutional law on the proportionality of punishment, and there's federal constitutional law. But that turns almost everywhere on an idea of gross determinant disproportionality, where a sentence almost has to be grotesque to be reviewed under the standard of gross disproportionality. So it's, to me, it's not an important implementation tool when thinking about a system that's based on that. Minnesota is one of the states, and some other guideline systems that have copied Minnesota that have really done a better job with this. And, you know, one of the basic concepts that I think the commission has applied for 40 plus years is that the guidelines themselves are one anchor of proportionality in the sentencing system. The guidelines are meant to be of general application. They don't get down to individual cases. But the idea of guidelines is that this is a, you know, a credible statement of what a proportionate sentence would be in an ordinary case involving a particular kind of crime, a particular kind of criminal history. And so the Model Penal Code adopts this and, you know, approves of the Minnesota system in this regard, that the commission has a lot to give in its collective judgment, because the commission represents so many different viewpoints and constituencies within criminal justice, that it has credibility to make these sort of general judgments of proportionality. And that is a powerful innovation that lots and lots of states have not benefited from.
Director Wright.
I'm sorry.
Oh, I just have a question on this slide, if I could.
Yes.
And it really ties into a discussion that we're about to have on the next agenda item, which has to do with looking at crimes that the legislature is anticipated to be creating this year, and the commission has to decide how to rank them. And we talk about ranking principles, and this really looks a lot like the ranking principles where we're looking at the harm done to the victim and the culpability or blameworthiness of the offender. And I get those two anchors, and those are very familiar to, I think, commission members who have looked at ranking offenses before. And that's really where the proportionality is, I think, set in. I think Commissioner Crutchfield raises an interesting point about what is the purpose of the horizontal axis. That's a different question. But let's just look at the vertical axis. The offense severity really ties into this proportionality discussion. What does that third anchor mean, or the first anchor, the gravity of the offense? What I get the harm, I get blameworthiness. I don't understand what gravity means in addition to harm.
Right. Well, what it meant when I put the words in there, what was that we should consider offenses serious sometimes even when no harm is resulted. That it can be a grave offense to shoot your gun at someone 12 times, even if you miss all 12 times. I mean, that's a high gravity offense, and yet. Well, I mean, the crime victim's probably scared, you know, I mean, there is harm, but the gravity of the offense in lots of instances outstrips the sort of palpable harm that was done. Okay. Does that make sense to you?
But that's in a general way, right? Because you're talking about ordinary cases.
Right.
So it's like the offense itself. You might commit it in multiple different ways, but the offense itself is grave.
No. I think it's meant to be, you know, across the board, and in terms of offense definition, it comes up in things like attempt and conspiracy, where the definition of the crime itself may not assume that the goal of the conspirators or or has been accomplished, or that the attempt actually added up to anything. But I think at a case specific level, it applies as well, because some, you know, there are some people who are just very lucky that the injury they caused was less severe than they might have. This is how I understand it now. These are all examples of, I think, the really interesting, detailed questions that can be asked sort of within the heading of proportionality And then within the heading of, well, what should the reference points be? Right? But to me, risk of serious harm needs to be in there, whether it's worded this way or is worded some other way. Does that help?
Yes, thank you.
Okay. Now, one thing that I think is missing in the vast majority of states and is present to a degree in Minnesota is the implementation question of, as a matter of sort of institutions in the criminal justice system, who has the responsibility to make sure that in a specific case, the sentence is not disproportionate? Okay, is there, the Guidelines Commission can be an anchor at the sort of general level in writing the guidelines, but are there mechanisms that exist in the individual case? And what the Model Penal Code says, and again, I believe in this, that there needs to be some sub-constitutional sense, not gross disproportionality, but some sub-constitutional sense that the appellate courts should be reviewing individual sentences for proportionality. Okay, and again, Minnesota is a leader in this in certain respects, maybe could go further, but without this, you only have one bookend. You have the guidelines, which are kind of one bookend, but there's no responsible party at the end of the day for individual cases. Now, the idea of sub-constitutional review of sentences is very rare in America. Okay, most American states say that, well, we won't review sentences at all unless there's a constitutional problem or a clear legal error, like the judge gave 30 years and the maximum authorized sentence was 5. Right? In a lot of states, that's about all you can appeal when it comes to sentencing decisions. But there have been some states that have done things much differently and have successfully instituted meaningful appeals from sentences. And Minnesota is probably the leader in this respect. Strangely enough, Alaska has been a real leader in this area, plus a number of other sentencing guideline systems that got the idea from Minnesota and have implemented it themselves, like Oregon, Washington, Kansas. There are other states that have followed Minnesota down this path, so that in Minnesota, there's appellate review of departures or even failures to depart. For departures that more than double the maximum term of the sentencing guidelines range, there's an especially stringent standard of review in the appellate courts. So Minnesota, maybe as much or more than any other state, has been moving in this direction of implementing, putting the money where their mouth is in terms of implementing and enforcing proportionality. The Model Penal Code, though, says that, well, all states, and maybe even Minnesota could go further, but that all states need to think about making the appellate courts the anchor or the bookend for proportionality in individual cases. And so this is one provision from the Model Penal Code that it's short, but it's kind of stunning or surprisingly different from what happens in a lot of states. And this provision says this is part of the different kinds of review that appellate courts can have depending on the issue. But this provision says the appellate courts may reverse, remand, modify any sentence, including a sentence imposed under a mandatory penalty provision, on the ground that it is disproportionately severe. Okay, so that goes pretty far, right? Even if there's a mandatory penalty. This is not something a Guidelines Commission can do. I mean, for this, at least to draw an exception for a mandatory statute, that has to be in statute. That can't be in the guidelines. But then the provision further says the appellate courts shall use independent judgment when making proportionality decisions, and that is meant to avoid the problem we see in constitutional law, where appellate courts say, oh, we have to defer, we don't really want to get into this unless it's an abomination of a sentence. We're not really going to play a role here. Okay, so the model penal code is trying to get implementation at the case level for ideas of, a safeguard in every case. And this, this is a responsibility that has considerably more bite than the constitutional rule. And especially when you talk about superseding mandatory sentences. But it is something that, to some extent, a guidelines commission can encourage. Individual judges, especially appellate court judges, especially Supreme Court justices, can think about these ideas in crafting the role of appeals in sentence appeals.
Can I ask you just to recap? I just want to check my understanding here for a second. I think we have a question. We have a question. Okay. So when we think about proportionality, so for instance, the severity levels that we have on our grid are a way to implement proportionality. The less serious offenses are on the bottom of the grid, the more serious offenses, and we've ranked them.
You've ranked them
based on those factors of harm and culpability. Right. So we've put that order in, and that's that first concept of proportionality where you're limiting it to the current offense. Like that's theoretically hitting that first concept. And then the broader concept of proportionality pulls in the past.
Or potentially, I mean, in the Minnesota guidelines and lots of other guidelines.
We've implemented that with the criminal history score. That's how we're currently thinking about it.
Right. And there's, there's another step besides kind of relating one offense to another, kind of grading within the guidelines. And that's actually filling in the numbers in the boxes or deciding where the in-out line should be. Things like that require a lot of value judgments that I think are human value judgments. And there's no equation for that, but it's something that sentencing commission members around the table can bring. And they have experience. Hopefully, the people appointed to a commission are, leaders and are experienced, and they bring that credibility even to the task of saying, well, where should the in-out line be, or what should the numbers in that particular box be?
Right. So we very clearly, as a current sentencing guideline, our current guidelines very clearly incorporate this idea of proportionality as one of the main sentencing principles, as a main sentencing principle. And we've made a lot of decisions about how to implement that. So those are the implementation pieces, all those.
Right. And a number of states have copied Minnesota. I mean, Minnesota's been very influential in giving this model, the 2-axis grid, to a number of other states that have pretty good working systems if you look around that.
Okay, I think more questions. So, Commissioner Knudsen.
So what you're just talking about now is the general proportionality of the guidelines. The slides toward the end here, we're talking about this concept of individual proportionality.
Exactly.
And no states have adopted this model code regarding this appellate.
Right. I cut some slides for time in the presentation, but there are states that have moved in the direction that I'm suggesting. And Minnesota is one, because Minnesota's been a leader. But in Michigan, I was surprised to discover in this go-round of research. There's quite a large body of sort of judge-made proportionality review in criminal cases that isn't the constitutional standard, but that reacts to this sort of feeling that the buck has to stop somewhere. There has to be some responsible decision maker at some point who's going to say, yes, there is a limit in this case. Right? Ohio for a while had something similar, but then its guidelines were declared unconstitutional by Blakely and Booker, and that seems to have evaporated. In Alaska, there's case law below the level of constitutional review that responds to proportionality. And in a number of other countries there is. You know, in Canada or Australia, you can find examples of an appellate court proportionality safeguard that's kind of a backstop to the rest of the process in an individual case.
But there isn't any statute or structure answering your question of who ultimately is this
Right.
Protector of this individual
Yes.
personality.
Yes, and that's, you know, it's interesting in going through this exercise of this research with Amy. You know, there are a lot of things that states have found, or the model penal code has found important about this topic of purposes and how they can be made to, you know, have meaning. And some of these things require statutory amendments. So as a sentencing commission can recommend statutory change. It can't do it itself. But you often have to parse, well, you know, which part of this can the sentencing commission take on, which part requires legislation.
Well, and can I just ask the question, why does it require any of that? Because if we have a system that recognizes proportionality,
Right.
ultimately, when you first started and you asked the question, I thought, well, it's obvious. It's the judge and the judicial system that has to be
Right.
the guardian or the ensuring the individual proportionality of each case. And so when you say, well, Minnesota and Alaska have kind of recognized this through case law, through the appellate courts,
Right.
without the guidelines suggesting or requiring or statutory statements that, or authority to review any of this or whatever, because I would argue that we recognize proportionality in general, and obviously you have to take that to the individual basis, and that's solely in the hands of the judge. And if it's not, then we're talking about guidelines on top of guidelines on top of guidelines, and mandatory this and mandatory that, and statutory telling us all the way along that we have to do this, we need to do this, we should look at this,
But
instead of the natural development and understanding within the system
Right.
based on the case law that comes from our.
Right. Right. I think this, you know, in the individual case, the sort of model penal code view of things is that this is the common law, right? This is trial judges and appellate judges developing a jurisprudence of their own from the cases that, and at least in my mind, this is just a credible, this is as credible a source of lawmaking in the individual case conduct as the commission is in the sort of general guidelines drafting role, because the common law process is never just any individual judge or individual justice. There's precedent and there's coordination and statements of principles there's evolution. So I don't see it as guidelines upon guidelines. I see it, I agree with much of what you're saying, that I see it as judges doing what they're uniquely positioned to do best.
I agree with that 100%.
Okay.
Director Wright, do you have a question?
Yeah, and so I just want to say that there is at least one jurisdiction where the appellate authority does have the opportunity to revisit sentence appropriateness. I was in the military for an entire career, basically, and so there's two levels of appellate courts in the military, and the lower level appellate court, there's one for each of the four services, and they have the authority. They actually have independent fact-finding authority, and they have authority to review the sentence for appropriateness. So it's a little bit different.
Okay.
Commissioner Fraze.
Okay, just to be, Judge Larkin, you had your hand up, but you passed?
I'll pass for now.
Okay.
Thank you.
So when you were surveying the states on purposes of punishment, did you find any suggestion that they are different, or at least different priorities when you're talking about the ultimate severity of punishment as measured by duration of prison versus the what we call the dispositional decision, whether they're going to go to prison right now or whether they're going to get a suspended execution or imposition? And the reason I ask that is it seems like even though we talk in Minnesota about principles applying across the board to both of those realms, not only the structure of the guidelines, but the case law under the guidelines makes a distinction in terms of purposes of punishment, I think. Or at least there's two different issues. There's the issue of, what's the number in the box, and there's a number of which side of the disposition line you're on. And the case law, when addressing departures, has suggested from the early 80s, and this was case law written by Judge Amdahl and other people who were on this commission, that said, well, when you're departing durationally, it's mostly about the seriousness of the crime. But when you're departing dispositionally, we can look at the offender in a particular amenability to probation, particular unamenability to prison, particularly unamenable to probation. And so those are offender-based. They tend to be risk-based as well as amenability. What are his needs? What programs are available? Does he or she seem to be amenable to those programs? So, in practice, in case law and even, in the structure of the grid, there is kind of a different set of principles depending which of those two realms you're talking about. Do you see that in any other states?
No, I should say that has perplexed me about the Minnesota system for decades. To me, severity and proportionality are infused in both the dispositional and durational decisions. So I've never understood that those lines of Minnesota case law, and I guess I would agree with the assumption that appears to be in your question that, well, maybe that distinction shouldn't be there. It's always troubled me, but I at least, and you have a lot of knowledge about different states as well, but I've never come across another state that does that separates those two aspects.
Well, you might need to get into the case law, and that's the hardest thing to do in an additional survey, even if you're just looking at the states that have a lot of case law. I don't happen to remember whether, I think some other states, like I think Kansas and maybe Washington, haven't been as open to the amenability concept. And this commission, frankly, was not very open to it initially because they thought, well, we have a just desserts model, and that sounds too much like utilitarian crime control thinking. But again, Judge Amdahl, the other justices, Judge Scott was on the commission and then on the Supreme Court, and they said, so I guess, I don't know if I misheard you, but I thought you were saying that I questioned that distinction. No, I think it's brilliant.
Oh.
I think it's one of the ways we harmonize these otherwise, conflicting purposes.
Yeah. Yeah, but, it's always been something that's puzzled me, and it's worth thinking about.
Well, and I will point out that when we initially enacted the 5-year probation cap within the guidelines, and because our structure allows for departure, we had to, we not had to, but we did build in the ability to depart from that 5-year cap. That sort of blew that distinction out of the water, because if you're going to do a longer probation term, it may not, it may or may not have been about the offense or the individual. So that was actually one of the struggles with that format, was the ability to depart on that. Commissioner Ladd.
Thank you. I guess one of the things I think about, and I don't mean to take an adverse position to Judge Knutson and the judge's role in all this, but I sort of feel like, the bulk of our cases get resolved short of trials, right? So we're working on agreements, and who's doing that are the prosecutors and the defense attorneys. In all those cases, this issue about proportionality or disproportionality is what's being discussed as to why this offender should get X and this offender should get Y. And so when you do that and you bring it to the court can either, agree to it or disagree with it, what have you. But I would say the heavy lifting and the weedy work is really with the practitioners that are working on that individual case. And to me, I think the anchor in that is we use the guidelines as, well, are we doing, do we have reasons to depart? And what are they? Are they mitigating or they're aggravating? This is what we're doing organically before it ever even gets to the judges. And in fact, I think sometimes even charging decisions are made that way. When you're looking at a case, is this, for example, is this a case where it is a second-degree assault versus maybe a lesser kind of assault, right? I mean, you're making those judgments and trying to determine in that particular case sort of what's appropriate. So I think that, the guidelines provide that for the people who are sort of doing this before it ever even gets to in front of a judge. Because most of these cases that we're talking about aren't trial decisions where we have a trial, there's no agreement on the sentence, and then the court is left with the decision about what to do about it. It really is the prosecutors and the defense attorneys that are grappling with this in all their cases.
Right. Yeah, no, I agree with that. And I think one of the great benefits of guidelines is that it defines the bargaining power kind of in plea negotiations, because it gives people a sort of relatively solid consequence of a fully litigated case. And I think a lot of plea bargains are based on a sense that if we went all the way to trial and appeal, what's our sense of what would happen? And the prosecutor has that image, and the defense attorney and the defendant have that image. But in a guideline system, you have so much information from the grid, and possibly from the case law as well, about what would be a reasonable thing to agree to or anticipate if you went to trial. And I think that's a huge advantage and makes the process more rational in Minnesota than it is in the vast majority of other states.
Commissioner, what role does culture come into play there? Because I agree with you in the sense that does the people who do this every day? They're going back and forth, and there kind of becomes almost an idea of, hey, this is a burglary, and this usually, and there's kind of a culture as to where these sentences go. And I'm wondering if it's different in the 2nd district versus the 4th district versus the 8th district. And so it kind of becomes more localized. And then my other question is generally is where does the PSI come in as far as reliance both on the guidelines and reliance in the sentencing?
Commissioner Ladd, do you want to try to respond?
Well, I don't know how it works anywhere else because I'm not working anywhere else. But what I will say is I think that, like, for example, I'll just use my office because that's a good point of reference. We have what I would call some standard dispositions for similarly situated defendants are going to get this. It's objective because that's how we're held ourselves accountable. And if we're going to move off center of what that is, and it's consistent with the guidelines and such, it's going to go up or it's going to go down. we want to articulate to not only ourselves, but to the defense attorney and to the defendant or our victims, why we're doing something different in this case versus these 10 other ones that were almost exactly the same, except for something else. And so I would like to think that everybody does that same kind of analysis and has that same kind of discussion in their cases, because we are not cookie cutters and, stamping things through just because, that's what we're doing. We are looking at the individual cases, but we also have to have some objectivity in terms of why we're doing what we're doing in the first place. And our starting point for me is like, okay, the framework for the guidelines that provides some guardrails. And I frequently say to a defense attorney, articulate to me what some reasons are, what's here, because I don't see any reasons for departure. I'm willing to listen. So I think that that's the approach that I take, and I would hope that that happens everywhere else, but I don't know that.
Thank you. Thank you.
Can I just add to that? I think guidelines are enormously helpful in making the process more objective than it would otherwise be. But there's no way to defeat the influences of culture and bias. I mean, human imperfections. You can't rule them out, but I think the guidelines help. They help put things in a perspective.
Commissioner McGrath, I just have a question. When it comes to civil commitment rates in Minnesota, is a high civil commitment rate an indicator that somehow the reasonableness of using proportionality in sentencing isn't necessarily working, or what?
That's a good question. I don't have any answer for it because it's intrigued me for years, but I've never done any research into this, that civil commitment is used more frequently in Europe than in the United States. And yet famously, prison rates are lower in Europe than in the United States. And I've often wondered whether there was that kind of a push and pull. But I can't go beyond the fact that I've wondered about that too.
And are you talking about in general, or are you talking about civil commitment of sex offenders after they've served their sentence?
I guess both. Just the general concept, I guess.
Yeah, and I can give you an example. When I lived in Colorado, there was a strong movement to create a sexual predator civil commitment system. And the sort of fiscal impact statement, showed that would be very expensive. And the legislature instead created much longer indeterminate sentences for sex offenders. So at least in that one negotiation of how things were going to come out, there was that comparison of, do you do it this way or do you do it that way?
And that same discussion happened in the legislature when the federal case came up. Well, how are we going to maintain this? What are we going to do? Maybe we need to go back just for these types of crimes and go back to indeterminate sentencing and take a look at that.
Mm-hmm. Now in Colorado, what it's led to is that even for minor sex offenses, you get a sentence of like 2 years to life or 4 years to life. I mean, that extreme indeterminacy. But that was a result of a decision largely for fiscal reasons, not to go the civil commitment route. Anyway, that's a different conversation. Okay.
Just a time check, how much time are you going to need on the next item?
As much time as I have, so probably do it in 15.
I'd say you probably have like 10 to 15 minutes more.
Okay, well, why don't I go through these slides more quickly, because I knew this is, I don't know, there are bookshelves of treatises just on the kind of issues that we've touched on today. But because the question has come up so often, what's the right sentence to impose? I was really attuned to looking through the state sources with that in mind, in this sort of research this last couple of months. And what I found, far short of a majority of states say something either in statutes or sentencing guidelines, if they have them, about what the purpose is of an incarceration. sentence should be, there's a smaller number of states that speak to the purposes of probation. And then there's some others that I'll talk about in a second, but it's always seemed to me that an organized framework that thinks about what the purposes of sentencing should be for each type of penalty would be useful. It would just help us think clearly about those issues. And like I said earlier, what really strikes you when you work on something like the Model Penal Code for 15 years? It really struck me that the purposes of sentencing really vary by context. What type of case is it? What type of punishment are you talking about? So the Model Penal Code says, and it gives this to the Sentencing Commission, that the Sentencing Commission should feel the freedom and guidelines to include presumptive guidelines or other provisions that prioritize the purposes of sentencing for specific classes of cases. So it's not always just one thing. It's not always just one understanding of proportionality or what we're trying to do. And let me give you some examples of that. The Model Penal Code has separate statutory provisions for a number of criminal sanctions. And each one of them, incarceration, probation, even unconditional discharge, even some diversion type dispositions, in every one, purposes of this particular outcome or disposition are stated separately. And for economic sanctions, it's the same thing. In fact, it's not on the slide, but the Model Penal Code gives a separate statement of purpose for restitution than it does for fines, than it does for costs and fees, than it does for asset forfeitures, right? So that at least there's this, a sense of, well, there can be a different program in different contexts. Now, New York currently, I found in this round of research, does something like this for quite a few of its sanctions in statutory law. Speaks to the benefits of institutional confinement, but what about probation? And then there are different levels of probation. There's probation with with conditions and supervision, and then there's a lower level of probation with conditions but no supervision. Okay, so unsupervised probation, which New York actually uses a lot of. New York has a sanction of unconditional discharge that doesn't include any form of probation, and then economic sanctions. And in each case, the statutory law speaks to well, what's the purpose of this one, or what's this, what's an appropriate use of confinement as opposed to probation, as opposed to unsupervised probation. Pennsylvania is another jurisdiction that has done interesting things in sort of pulling apart the sort of levels of sentences. In their sentencing guidelines created and statutes, and guidelines, not statutes. The Sentencing Commission has created 8 sentencing levels, and each of these 8 sentencing levels has its own statement of what the applicable purposes are for that level. And these 8 levels are actually shown up and they're kind of color coded on the guidelines. Right? And maybe I should jump ahead because just so I can show you what this looks like in Pennsylvania. These are the New York statutes. But this is sort of small, but this is the Pennsylvania guidelines grid. And what you might be able to see is down in the lower left, things are colored in yellow. That's considered level A territory. And then above that, there's a band for level B sentences. And above that, level C, D, although it goes from A to G. And for each of these levels, the guidelines express what the operative purposes should be for this kind of sentence to be imposed. So level A is called in Pennsylvania that these are considered restorative sanctions. This is, you're not even going to give a probationary sentence, but the use of restorative sanctions focus on reparations, things like restitution to the victim, restorative justice. And that's the purpose there. But as you move up the levels, when you get to supervision with minimal control, now this supports the utilitarian purposes of rehabilitation and restoration. If you go up to another level, probation with restrictive sentencing conditions, now we're talking about deterrence as well as rehabilitation and things like victim restitution. And when you go up even further to the sort of confinement, state penitentiary confinement, the primary purpose at this level is now incapacitation and deterrence. Okay. Now the point of going through this is not that Pennsylvania has done a perfect job of defining these different levels, but it's a very useful way to think about the question of what should a sentence be in a particular case, and that different cases do not really implicate the same purposes, right? There's a different prioritization or a different selection of the really big primary goals we can achieve for one type of offense as opposed to another or in another case. And I flipped through this, but New York does something similar in its statutory law, where it gives us a statement of what are the purposes of probation, why is that different from a confinement sentence, what about conditional discharge without supervision. And one of my favorites is that New York speaks in statutory law about the purposes that are operative when imposing a fine and the concerns that should be in the judge's mind. So this more layered general framework approach is one that feels promising to me, that some states have implemented. Pennsylvania's been doing this for a long time, and that I just wanted to bring to your attention. And then the last thing I would go back to is because more states address this than other questions. When is incarceration appropriate? Okay, and the Model Penal Code has a provision on this that's on this slide. The lead purpose of incarceration is when incarceration is necessary to incapacitate dangerous people. And looking across the states, this thought comes up over and over again. In Delaware, incapacitation is meant for the violence-prone offenders. In Kansas, incarceration should be reserved for serious violent offenders. In the North Carolina version of sentencing guidelines, the use of prisons and jails should be prioritized first for violent and repeat offenders. Now, these statements of purpose, just like other things I've talked about, raise the question, well, you can say that, but how do you actually implement it? Right? And one of the big questions is, how do you know when someone's a defendant in a particular case, whether they present a high or low risk to public safety? The traditional American approach is that the judge is given the job of exercising judgment, the judge's view on that question. But it seems to me that it's useful to ask that question, but also ask a question that's easier to answer, which is, are there ways to identify particular defendants who pose an unusually low risk to public safety? I don't think there's any way to have perfect information across the board in terms of who's dangerous, who needs to be in prison because of a threat to public safety. Very difficult to answer that with confidence across the board, except for people who are in the basket of unusually low risk of recidivism. Okay, and there's a lot of empirical research, statistical research on this question that shows that rates of true positives or correct predictions when we try to find people who are especially likely to commit a serious crime are not very high. Okay, they're actually impressive compared to just chance, but you make a lot of mistakes when you try to predict who is especially likely to commit a serious violent crime. But if you turn the question over and say, is there a way to identify those folks who are really, really unlikely to commit a serious crime of any kind? There's a lot of statistical power in risk assessment instruments to do that, right? To identify people who don't need to be in prison. And I won't talk about it at length, but Virginia has a very highly developed system for this, where the State Sentencing Commission developed a one-page risk assessment instrument. This is the instrument for larceny that focuses mostly on different aspects of the prior convictions, but also on age and gender, and generates risk scores just based on a one-page instrument that, based on their research, are very highly correlated with recidivism rates from that population. And what the Virginia Commission found based on its recidivism data in the state of Virginia is that roughly half of drug and property offenders who come to sentencing where the guidelines recommend a prison sentence, and this is Virginia, it's not other states, but in Virginia, roughly half of the defendants coming to the court for property and drug offenses were well down in the single digits of risk of recidivism. Right, so this graph shows you the accuracy or the predictive power of that one-page instrument, at least in Virginia. But what it doesn't show you is that an awful lot of the folks who were otherwise prison-bound for property and drug offenses are way down in that lowest level. Okay, so this is, this is something that's really caught my interest over the years. That we may not morally or with any real intellectual confidence know how to say who the worst offenders will be in the future. But we're very good even with very basic actuarial tools at identifying large numbers of people who pose very little threat. And maybe we should use that at sentencing. In a lot of states, this is what's used to make parole decisions when you have a parole board. Virginia has moved it into the sentencing stage, and a number of other states, including Pennsylvania and Kentucky and Tennessee, have weaker, more indirect ways of doing this. But in Virginia, the judge is told, you know what, if you get someone and the guidelines recommend prison, but you get this low risk score, you should give that serious consideration whether to depart from the prison recommendation, right? Depending on how you want to write your guidelines, you can say it's not going to count as a departure if the risk score is that low. And some people in Virginia have advocated that if you're way down in the risk score, the presumptive sentence ought to change from in to out. It doesn't bind the judge, but the presumptive sentence moves. So just on the subject of implementation, if we think the primary purpose of incarceration is confinement of people who need to be there because they're a threat to public safety, is there a way of identifying what's possibly a meaningful share of your total sentence population every year that is not in, we can say with confidence, is not in that group? And again, it's an implementation question. So I think that's where I'll stop since over time.
Yeah, sounds good.
I appreciate the discussion. It's been very helpful. And the focus obviously was, okay, using incarceration to incapacitate people who pose a danger to other serious violent offenders. But I wonder if we need to keep in mind that incarceration could serve another purpose, just in terms of accountability to communities. Because I'm thinking of, the Bernie Madoffs, the identity fraud that, hurts so many people and has a huge financial consequence, but no one's physically hurt.
Right.
You know what I mean? So are we to say, well, for those people, well, no one really faced any physical harm. You have a low likelihood of reoffending, so you don't deserve a consequence, even though our statutes, and I think even departure factors, can be based on the high financial impact of a crime.
Right. And I agree with what you're saying. I mean, the model penal code says that.
What do we do with those folks?
Yeah, that there are people who need to be in prison because of the severity of the offense. Okay. And just the need that justice requires. Right. So there are going to be Bernie Madoffs and, a lot of serious offenses that would be in that category that's simply for retributive grounds, right? So what the model penal code says, and what I think, some states could clarify, but there are an awful lot of people where that's not the basis for an incarcerable sentence. And so if we take out that, a serious crime category, a very serious crime category, then you have to ask yourself, okay, for the rest of the people, what are we doing, or what are we trying to do when we impose a prison sentence?
Thank you.
Any other questions or comments? You've given us a lot to think about today.
Oh gosh, my head has been hurting for the last several weeks. Just
Trying to figure out what to say.
And Amy and I generated a document almost 200 pages long with various provisions and case citations and so on. And just going over that impresses on me this is a big subject.
It really is. It really is. And I appreciate the work that the two of you put into this. And I also appreciate the attention. I know you've been at pretty much every meeting we've had this season. So I really appreciate the attention that you gave to the burning questions that we keep raising. It's really given me a lot to think about. I think it's given everyone here a lot to think about. Commissioner Larkin.
Can I ask just Nate to make a note, because we're going to cover so many different topics. And like when I've heard something, I think, oh, that's really sounds like a good idea. I'd like to say, I think it's a good idea to be forced to think about what the purpose of any particular sentence is in a given case. Mm-hmm. And I don't know that I like that idea of a grid that sets that out, but maybe adding something to the guidelines that says, here's the purpose of unsupervised probation. Here's the purpose of supervised. Just so then a judge could kind of look at what he or she is considering and decide whether or not they align with those purposes. Now, I don't know how that works, though, when you've got presumptive commit or presumptive non-commit, and now you're looking at these purposes and what if they don't align? Is that a departure basis? So I'm not sure how it works, but I do think the grid is so useful for all the reasons that have been discussed. But I think there's also then a tendency to be like, well, the grid's the grid. There's nothing to discuss. So those purposes maybe would enable a little more thought and discussion.
I actually had a similar thought. I I can't remember which state you put up there, but I was really intrigued by that idea of defining the purposes of those different sentence types.
Components, yeah.
Yeah, because that, not only, like, it might just be a good discussion for us to have to see if we can get to an agreement on what those are, because those could even help us guide some decisions down the road and decide in, thinking about even where the structure should land when we think about the purpose of probation is this and the purpose of, I can't remember what all the different types of sentences were, but that there might be different reasons to put the disposition line in a particular place because of those purposes, so I was intrigued by that as well, and I think that might be something that we would want to have something to look at a future meeting.
I just had a question about Pennsylvania. So Pennsylvania just went through a comprehensive review.
Right.
It's kind of a model for what we're doing. Is what you showed us the outcome of that
Yes,
comprehensive
that's
review?
2024.
Okay, so
And-
that's what they came up with.
And they've had guidelines with zones before. I think they came in the 90s. But it's a more sophisticated version of something that they began to work with probably 20 years or more ago.
Commissioner Ladd?
One other thing that I think I'd like to kind of piggyback on what Judge Larkin has indicated that I think is good discussion in terms of like purposes of these various things. And this is a thing we don't talk about a lot, but I hear a lot as a prosecutor when I'm talking to people, as I'm required to do with victims in cases. There's a component of this that is really just about punishment, nothing else. I mean, that is a piece of this. Now, and again, it's a small piece, big piece, whatever. And again, the kinds of cases and the kind of victims you have involved in those things really kind of dictate that. But I think we would be remiss if we didn't acknowledge it. And I sort of think we talk about all these other things, but there is a part of this. And again, I don't know the framework of it that's just about punishment. And I think we can't forget that as we're looking at all these other things. I think it's an ingredient of many things that we should be considering.
Right. And when I think about proportionality, that's what I think about. That there's a certain range of punishment severity that's justified in each type of case. And it's, or offender accountability, if you want to put it that way. But to me, that's, part of what's so useful about the way Minnesota and other states have structured things. The proportionality is kind of a separate concern from, well, what do we think we can achieve in terms of future crime reduction here? But I think the two interrelate.
Like you should put that on a piece of paper so we can keep looking at that. Like what you just said about punishment versus proportionality. Anyway, I don't know which one of you is more directly on point, but Director Wright and Commissioner Fraser, you both had comments. Commissioner Fraser will comment.
Just another way of thinking about accountability and sort of justice requires that Bernie Madoff, or for that matter, any murderer, go to prison. Another way of thinking about that, and I think this was the language of the first model penal code. I don't remember now whether it's in your revised version, but the idea that some crimes require sort of what we call in philosophy a punishment, hard treatment, going to prison, to not depreciate or deprecate the seriousness of the crime, to reinforce the norm, the value that don't do this. This is really horrible conduct. We all abhor it. And we show that with a severe sentence. And you could say that's really a utilitarian argument. The sentence is saying that we need to reinforce these norms because that's what really makes people obey the law. They're not usually thinking about the possible punishment. They're just, abhorring something. That's really horrible thing to do. So anyway, it's a way of saying, well, maybe it's a kind of a retributive just desserts minimum, or maybe it's that we really have to uphold these values.
Well said.
Yeah. Director Rice?
Yeah, and I tend to oversimplify things just so it fits inside between my ears, but isn't there some way in which the two axes of the grid are sort of looking at those first two things on one of your first slides, looking at proportionality is sort of the vertical axis and public safety is the horizontal axis in a way, kind of looking at more of the utilitarian things on the
Right.
horizontal axis and looking at, this is the minimum that justice demands on the vertical axis.
Right, and there are states that we ran across that describe it in just that way. But it surprises me how many states currently say before anything else that criminal history is just as important to proportionality of punishment as the current offense. Right, and to me, it has more to do with recidivism danger, or that access of the grid should have more to do with that. But it surprises me in looking around the states that at least that's not the way it's expressed most of the time in those states. In their statutes, in their guideline pronouncements of what they're doing.
All right. I hate to cut off, well, I'm probably not, we might have exhausted the conversation. I didn't want to cut it off because it was such a great conversation. Thank you so much for putting this together and bringing this. Like I said, it really gave us a lot to think about, and I think the comments and questions that were asked here really reflect how deeply you're forcing us to think about this issue, and I appreciate that. Thank you.
Well, it has the same effect on me.
All right, and so to think about our own version of proportionality in all of this, I'm going to hand it over to Director Rice because we actually have a practical application coming up. The legislature is winding up, and pretty soon, assuming they can actually get to the end with some of these bills, we might have some new offenses to incorporate into the guidelines. So I'm going to let Director Rice go through our process for that and give you a preview.
Thank you, Madam Chair. And just a little housekeeping note, the last two slide decks that you saw are not online yet because we received them basically after we printed the materials, and for open meeting law purposes, we can't have printed materials. We can't have things in your possession that are not part of the printed packet that's here in the room. So everything will be equalized after the meeting. You'll get the materials and they'll be posted online for the public. So this is the June ranking preview. We're going to be looking at a few bills that that may require commission action. There's one change that we know will require commission action, or we'd like to see commission action. So why do I say June? Why is this a June preview? So, and this is really review for some of you and new for some of you because this is your first full year in the commission. So each year's changes to criminal statutes ordinarily take effect August 1st. That is the default, and if it's not the default, that's when the legislature habitually specifies the effective date of crimes. So August 1st is the day that we're looking at. So because of that, the sentencing guidelines are ordinarily also updated August 1st. Why? Because we want to have the two be consistent. We don't want to have offenses that exist in law and that somebody could be punished for, but aren't mentioned in the sentencing guidelines, or have conflicts between the sentencing guidelines and the statute, or it's possible that a crime's been made more or less severe, so the current severity level doesn't work anymore. So to meet that August 1st publication deadline, there's several things we have to do under our current meeting rules, which we'll get a report from the rules subcommittee later on, but the commission has to propose the changes at its June 6th meeting. So we have to take action at the next meeting. So we need a quorum. We haven't had a problem with quorum, so I'm okay with that. But we do need to come to the June 6th meeting prepared, having read ahead and ready to take action. It's not final action, it's preliminary action to make a proposal, but it's still action. And then the public hearing has to be held July 18th. If that seems like a long time, we won't get into the reasons for that, but there's a reason why it has to be 6 weeks after the meeting, and most of that has to do with state register publication requirements that are currently in our rules. And then the next week also can't be the same time as the public hearing under our current rules. The next week, the commission would take final action on July 25th, so just in time to publish the sentencing guidelines on August 1st. So June 6th seems like a long time before August 1st, but it's really pushing the deadline pretty tight. So the main task in June is to assign severity level rankings to new and amended felony crimes. And I feel like I can breeze through this because we were just talking about a lot of this. Professor Reitz was leading us through, he talked about the level of harm and the culpability of the offender as really being two of those proportionality anchors that we have. And that those proportionality anchors are the traditional bases for ranking decisions. Now I put in the words typically there because it's the level of harm that would typically be caused by the offense. That's kind of what the guidelines are getting at, is this is the presumptive sentence for the typical offense at this severity level, this criminal history. And the typical culpability of the offender. Other things that are considered are the legislature's statutory maximum penalties. That's certainly a signal that the legislature often uses as to how severe the legislature thinks the offense is, and also how similar offenses are ranked. So kind of, again, going to proportionality, you want to keep similar crimes ranked similarly. Alternatively, the commission can leave an offense unranked, so the courts can assign the offense's severity level on a case-by-case basis. So at that point, the court kind of becomes the mini sentencing guidelines commission for that particular case to decide how severely that particular offense should be ranked. Typically, unranked offenses are rarely prosecuted, cover a wide range of underlying conduct, or are new, and the severity of a typical offense cannot yet be determined. So keep that in mind, especially for one of these cases. I'm thinking, I don't mean to prejudge anything, but there may be some of these offenses that rational commission members might decide, just let's keep it unranked and see how it goes. See what these cases typically look like. Other decisions that may be needed: should the offense be added to the list of offenses eligible for permissive consecutive sentences? So it used to be that the sentencing guidelines said that crimes against persons can be sentenced consecutively to each other, but that was considered to be a little bit vague. So they just made a list of essentially crimes against persons, but it's called offenses eligible for permissive consecutive sentences in Section 6. The second is, should the offense be added to the list of severe violent offenses? That's a very small list, Section 8, where repeat offenses are punished more severely. And are there any other modifications that had to be made to the sentencing guidelines? So why these particular bills? All these bills have passed through the committee process. There are no obvious obstacles to final passage. Looks to me like they're going to pass. And there appear to be sentencing guidelines implications. Of course, I'm not a prophet or a mind reader, so I don't know what's going to actually happen in the legislature. So you may be seeing different bills in June that are not shown here, and you may not be seeing all of these bills in June. But just trying to give you a little bit of heads up as to what I see coming down the pike. So the first one has to do with firearm storage requirements. Minnesota statute 609.666 creates a gross misdemeanor, so not a felony, nothing that's ranked under the sentencing guidelines right now, for negligently leaving a loaded unsecured firearm in a place where somebody knows or reasonably should know that a child is likely to gain access. The bill basically rewrites 609.666, so it replaces it entirely, and it creates 4 tiers of offenses. So all these offenses require leaving a firearm not secured, either in a gun locker. I'm calling it a gun locker. That's not a statutory term, but it could be like a safe, or it could be a lockbox, or it could be a gun room. But some kind of a place where you can lock up your gun, or unloaded with a locking device. So you can leave it loaded in the gun locker, or you can leave it just with a locking device on the weapon, and then it must be unloaded to be considered secured under the statute. So that's a requirement for all of these. If it meets this requirement, it's a crime to leave the weapon this way. And there are a number of exceptions where you can leave your weapon for a little bit, but that's the basic crime. If the weapon is loaded, then, and this would be, I guess, in the case of a locking device. So if you have it with a locking device and leave it loaded, then it's a gross misdemeanor. It's a 3-year felony if an unsecured loaded firearm is accessed by a child or somebody who's not eligible to possess a firearm due to a prior felony conviction. And it's a 5-year felony if the unsecured firearm is used in a felony crime of violence or to inflict substantial bodily harm or worse. So the commission staff estimated that the impact of this bill would be 1 prison bed. This bill passed the House last week, so it's cleared the House and it's waiting a Senate floor vote. The next bill that I'd like to bring to your attention has to do with binary triggers. So current law, Minnesota Statute 609.67 outlaws machine guns and trigger activators. And trigger activators are devices that basically raise a semi-automatic weapon to the level of fire that you typically see with an automatic weapon. The legislature last year just raised the statutory max considerably. It used to be lumped with sawed-off shotguns. They raised the statutory max considerably to 20 years. And the commission viewed that as a strong legislative signal that the legislature intended that this be ranked more severely. So it ranked it at severity level 8. And those who were on the commission last year may recall that particular decision. So the bill, and this is House File 2609, which is this slide and the next slide, the bill adds binary triggers to the list, to the definition of trigger activators. Binary trigger, I hadn't heard of this, but it's a device that you pull the trigger, the gun fires, and then you release the trigger, and the gun fires again. So basically, you get for each trigger's squeeze, you have the opportunity to shoot twice, and you can watch YouTube videos of people shooting these at ranges, and they can really. It is pretty impressive how fast you can send the bullets out of the firearm this way. It does approach the semi-automatic rate of fire. I'm sorry, automatic rate of fire. Staff assumed no MSGC action. It's not really necessary for you to take any action on this. It just would stay. It would become at that severity level 8 level. This also passed the House last week. I'm sorry to present obsolete information, but as of like 25 minutes ago, this has passed the Senate as well. So this is now passed the House and the Senate. They are different versions, so it will have to go to conference committee. And I didn't really analyze the difference. There was some difference in the definition of binary triggers, and I haven't had time to analyze that. So straw purchasers is the other half of House File 2609. And both of these are kind of a rise out of the tragedy that happened in Burnsville with the 2 police officers and the first responder being killed. So that currently, it's a gross misdemeanor to transfer a pistol or semi-automatic military-style assault weapon to someone who's known to be ineligible, and that's a gross misdemeanor, and it's a felony if the person then turns around and so not the defendant, right? The defendant's being charged essentially with somebody else's crime. If the felony is turned around and the firearm is turned around and used or possessed to further a crime of violence within a year after the transfer. And the commission has ranked that felony at a severity level 2. So the bill elevates the gross misdemeanor to a 2-year felony. It expands the scope to include all firearms, not just pistols and semi-automatic military-style assault weapons. And it relaxes the knowledge requirement. So instead of being that the person's ineligible, it's reasonably should know or know that the person's ineligible. And it specifies a 5-year statutory maximum for the existing felony. I should say that the Senate added an amendment that appears to add another level of crime, and I haven't had a chance to analyze it, but basically that's if within the year period, the person doesn't just use it to commit a violent crime, but uses it against a police officer or other, I'm not sure exactly who's included, but I know police officers are included in that group. So there's probably gonna be another felony that you're gonna have to look at. And I say probably because a very similar amendment passed the House with flying colors. Unfortunately, well, I shouldn't say unfortunately, but it for procedural reasons that it didn't go anywhere because it was an amendment to an amendment that died. So, but it looks like both the House and the Senate are in favor of that additional crime involving police officer victims. So look for another offense that's not described here that you're going to have to look at ranking. We didn't estimate any prison bed impact to this bill. And as I said, this is also passed. So it's not awaiting Senate floor vote. Next offense, last new felony that I'm going to describe. So this is kind of a light year, just in case you're kind of setting your expectations. Sometimes we have pretty much our June meeting is consumed with looking at the legislature. I don't think that's going to be the case this year. So there's no current law outlawing the commercial sale of human remains. There's an existing crime of disturbing burial grounds, which is ranked at severity level 3. So maybe that's something that the commission wants to cue off of when it's looking at how severely to rank this new offense. But the new offense prohibits the commercial sale of human, skeletal, or cremated remains, with exceptions. Apparently there's literally websites where you can buy skulls and things like that. So this would be a 5-year felony. We didn't estimate any prison bed impact, and this is awaiting both House and Senate floor votes. The last thing I want to talk about is the corrected targeted misdemeanor list. So the sentencing guidelines assign, the criminal history score under the sentencing guidelines can increase if the defendant had a prior targeted misdemeanor, multiple prior targeted misdemeanors, or if the defendant was on a custody status for targeted misdemeanors. Although that's a whole other can of worms. The 2023 legislature simply changed the targeted misdemeanor list, which the sentencing guidelines echo in Appendix 5. It's really just a reference list, but unfortunately, when they added the list, they added a nonsensical offense. There is no such thing as 609-749 obscene or harassing telephone calls. And the commission, you may recall, last fall recommended legislative action. The legislature took action. So now it's corrected to 609.79 obscene or harassing telephone calls, which is a crime and is a misdemeanor, in fact. And so that's actually passed. So that is enacted in law. So that's one thing that we'll be asking you to do in June is just update Appendix 5. The legislature or the commission just kind of didn't touch Appendix 5 last year because it didn't make any sense. So that's the end of that presentation, Madam Chair.
Any questions on the preview? All right, hearing none. Looks like we're up to Executive Director's report.
Thank you, Madam Chair. So just, I think 4 things to quickly report. One is on demographic impact statements. So we had 2 bills this year that we were asked to do fiscal notes on, that after doing the fiscal notes, we determined that the bills met the significance threshold for demographic impact statements. One of the bills we were not able to do a demographic impact statement on because of the assumptions that we had to make in getting to our prison bed impact. Basically, we didn't know who the people were. We were just kind of assuming a percentage of people would anyway, we can only do a demographic impact statement if we can actually have a legitimate basis for assuming what the demographic profile of those people will be. So I did send the legislature a note saying that we weren't going to do it, but it did have some relevant demographic information that the legislature may find useful, but it wasn't an exact match to the profile of the people who will be going to prison under that bill. And by the way, the bill is not going anywhere unless a miracle happens. The other bill that we're doing a demographic, and that had to do with changing the list of crimes of violence, adding protective orders to that list, for which permanent disqualification of a firearm results. The second bill that we are doing a demographic impact statement on also probably isn't going anywhere, but I think it's a useful exercise to do the demographic impact statement. So there is a provision in the policy that we don't have to do one if it looks like the bill's dead, but I think it'll be useful to do one, and it is an interesting bill having to do with a legalization of paraphernalia I'm sorry, legalization of trace amounts of a controlled substance. And as far as I know, that's not necessarily a live bill, but it is interesting to look at the demographic impact. In this case, it's going to be prison beds reduced and felons reduced, but some interesting demographic profiles there. So we are planning on wrapping that up, I hope tomorrow, and sending that out to the legislature tomorrow. That's my goal. And so we'll have that presented to the commission next month. The second thing has to do with expense reports for the fiscal year. So the fiscal year end is next month, the end of next month. So if you have expense reports that you've been sitting on or meaning to submit, so that would be mileage, or in the case of public members, your per diem, then please submit those before the end of the fiscal year. The legislative session does end next week, so we're seeing things kind of come to an end there. I guess that's my legislative update. I already kind of gave you that. And then the final thing would be that hopefully the registration email for the National Association of Sentencing Commissions annual conference should go out today, if the secretary has time to do it. I'm the secretary, but hopefully that'll go out really soon, and that's coming up in August. We haven't exactly decided how many seats we're going to have, but basically I have a spreadsheet where we typically invite, we're able to fund some staff members and some commission members to go to the conference each year. So I will send invitations to those people who are with the details for those who are eligible. And the way I do it is I've got a spreadsheet, and if I extend an invitation, you go to the bottom of the list, whether you accept the invitation or not. So that's just kind of how it works. Sorry about that. Well,
It's harsh.
all right.
When is it?
It's early August. I want to say 6th through 8th, but I don't know that for sure. But
I don't think that's proportional.
That's fair. Yes, but it is a rule, and so it's the same for everybody. So I guess you got that going for us. So I think that concludes my report, Madam Chair.
All right, any questions on the executive director's report? All right. And last item is Administrative Rules Subcommittee update. I presume Commissioner Nixon, that's you.
Sure. As you know, we've got three of us, Commissioner Moran and Commissioner Middlebrook and I are working with staff to take a look at revising our rules. Minnesota Rules 3000 govern the procedural operations of the sentencing guidelines. And as you saw from the executive director's report, how we have to schedule our meetings, our proposed changes, and then the public hearing is kind of cumbersome. And we're barely able to get in those requirements under current rules before the effective date of those statutory changes, when everyone will be looking at the sentencing guidelines to figure out what to do with these new crimes. So as I understand, the commission has always struggled with those issues, and we want to try to streamline it, clarify it, reduce some of the steps, but ensure in all cases that those public hearings take place, there's sufficient notice, and the public is invited to comment. So we're looking at modifying those rules. And then when we talk about rules, we've got procedural rules that the commission has adopted. We've got statutory rules. We've got the Minnesota rules. All these rules tell us how we need to operate. And I wasn't aware of half of them. So the commission has staff has done some work on looking at creating a set of bylaws. And so that's the other thing we're looking at and hoping to recommend to the commission to adopt a set of bylaws that kind of incorporates all of this, makes sense of it all, and is a one-stop shop, so to speak, to guide the public and the commission members on how we do our work. So we've had 2 meetings so far, and I just want to thank the staff. Fortunately, they previously had done quite a bit of work, and so we're reviewing that and kind of honing in on what we really do need to change, and not being too prescriptive and making a lot of changes, but hopefully we will have something next few months. We've got another meeting coming up. Commissioner Marin or Commissioner Middlebrook, anything you want to add?
No, Judge, you summed it up well. Thank you.
I would agree.
All right, any questions from anyone? All right, thank you so much. I actually want to thank all 3 of you for taking on this task, which it really needed to be done, and I so much appreciate the work that's happening behind the scenes to get us to the end on that issue. All right, I think we have hit everything down. So I think we're down to public input.
All right, so members of the public, just see who's on. Okay, if any member of the public, looks like you're all on by a smart device or a computer, so you should have the ability to raise your hands. So if anybody who's attending would like to make a comment, please raise your hand at this time and I will unmute you. Otherwise, we will assume you do not wish to make a comment. Madam Chair, I'm not seeing any hands raised.
I'm not seeing any either. All right, seeing none, I think we have reached the end of our agenda. I can't remember what the next date of the meeting is, but it'll be in June. I can tell you that much.
I think it's the first Thursday in June.
First Thursday? Here, I probably can check.
June 6th.
It's June 6th. It was in my slide.
Oh, yeah, that is coming up. Yep, so the next meeting of the commission is June 6th, 2024. We have reached the end of our agenda today, so unless there's any objections, I will adjourn the meeting. Meeting is adjourned. Thank you very much. We'll see you all next month.